minutes. If you want to take an opportunity for a few minutes to give an opening statement, if you could please tell us something that we cannot read from your application, because we've all thoroughly read your application. Then the committee will have some questions. The floor is yours.
All right, thank you. Obviously, I don't think there's enough space in the application, and in your mind, you're probably thinking about June 2nd of 2014 when I had my incident that went viral. That particular day, the public defender and I had a conflict argument. It had been brewing for 3 months since he had been demoted from the felony division where he had been for 10 years. So he just wasn't doing his job, and sitting there at the bench, I could hear him being abusive to his clients. They were complaining that they needed to be at work. They can't keep taking time to come to court. They needed to resolve their cases, and he's just very rude with them. I had just been on vacation for a week and at a conference for a week, so we had plenty of time to talk with these clients over that 2-week period leading to the docket signing that day. The video, which went viral, was only a minute. It's really a 2-hour thing. As he talked with clients, he'd come forward, and it just was just a bad situation all morning long. I finally had enough, and one of the quotes is, if I had a rock, I would throw it at you, which the Supreme Court didn't like. But it was really just a shot over the bow, trying to get his attention so that he would do his job properly and represent his clients. It escalated even further. I was telling him to sit down. He refused. He was arguing back. And that's when I said, well, if you want to fight, let's go out back. And then you'll see there's a hesitation. And I don't know why I said it, but I said, I'll beat your ass. Totally inappropriate. And not only did the Supreme Court remove me for that, but the bar did follow on prosecution where I was found to have minor misconduct. When I entered the hallway, and this is what was not cleared up by all the hearings and such, was that I did not hit the public defender. He came through the door and he hit me right here. And there were photos of the bruises from that. And I grabbed him by the shoulders and only acted defensively. I tried to throw him to the ground, but there was a 3/4 full shredder bin, which kept me from throwing him to the ground. And when that didn't happen, I recocked and tried to do it again. That's when the deputy entered the hallway, and it broke up. I did return to the courtroom, and I addressed some clients who weren't very well represented by a lawyer, but I shouldn't have done it. And it's just a very regrettable event. The Supreme Court, in their order, did say that other than this isolated incident on June 2nd, Judge Murphy has been a good judge. And if you looked at the application, you see there's a lot of great things that I did during the time that I was a judge. I just thought it was kind of interesting that the timing of our conversation today is while there's protests going on in Washington as Judge Kavanaugh is going through a very trying situation in his confirmation. Anyway, I'm ready to address any questions you may have.
Dan?
In your current practice,
Yes, sir.
how does your current practice lend itself to being a circuit judge?
Half my practice approximately is in the estate planning, elder law, probate, which is mainly circuit court activities. I do my pro bono work through being an advisor, which is an attorney in a guardianship action for the ward. I also do, the other half of the practice is criminal, but it's mainly in county court doing DUI cases, although I do take felony cases on a very limited basis, which is circuit court work.
My question is, what translates from your current practice to being a circuit judge?
Really really, I think it's using your mind, and that's what translates. And as you can see in my application, I put orders that I produced as a judge in each of the divisions of the circuit court. So using your mind, analyzing, researching, and writing is all which directly applies.
Don?
Good morning, Mr. Murphy. I want to say first, I enjoyed reading your application, and your military service is extraordinary, so I want to take the opportunity to thank you for that. And also, you addressed the incident that occurred several years ago. In evaluating what happened then, are there steps that you have taken to ensure that something like that would not happen in the future?
Absolutely. I was suspended, for lack of a better word, for a month, and the chief judge, which at that time was Judge Harris, said, you know, do an anger management situation, and then I think we can reinstate you, which I did. But at that point, I didn't stop. I continued counseling for over 2 years because of this event. When my counselor, who testified in front of the Judicial Qualifications Commission, said that there wasn't anything further he could do. He thought I had a well comprehension of what went on that day, and he had the opinion at the hearing that it wouldn't ever happen again.
Phil?
John, good morning.
Morning, sir.
We're, I guess, concentrating on the incident. As I sit here and reflect upon it, I guess the question, if it is the question that throwing out here is, it happened. Most people here know the results. Many of them know what you were doing before that and your service to the country as well. So we're sitting here as a committee because there's a vacancy on the circuit court. There's not a vacancy on the county court, but at some point there will be, I'm sure. So the issue that sort of goes through my mind is, given the totality of your experience and the fact that you were on the county bench, that would it be more appropriate if you were to return to the bench through an appointment process, that it would be the county court rather than the circuit court?
Well, I would say no, I think is the easy answer. Why? In the past, I have applied for positions as they became available. I applied at the 18th JNC twice. The last time I did that, I was on the short list, and although you don't know, I think it came down to Judge McKibben and I, and she got that appointment. I also went through the process, and I made the short list twice for the 5th DCA. So I think that, you know, once you get appointed in the county court, you're kind of limited in the way you can move up, and that's only through appointments, which I sought to do during the time I was on the county bench.
Thank you.
Yeah.
Sir, thank you very much for your military service. I wanted to say that. It means a lot to me and others. And Ms. Fallon had the same question I had, and you answered.
Captain?
No questions.
David?
The reality of what is interesting to the governor in making an appointment is that his appointment will be able to stay on the bench for a long time, so electability afterwards. Can you give your thoughts to us as to why what happened wouldn't sort of sink a future candidacy of yours?
Well, you know, this incident, I think, would only help elect me. And it's unfortunate, it's because of the misperception that people think I actually punched him, as he said. And he did testify to that at the hearing. He said I hit him twice so hard that he saw stars, yet there were no markings whatsoever. I also find that pretty hard to believe, since I had bruises here and here, and it'd be hard to do that. So I have been encouraged to run for a number of positions outside judicial. In fact, currently there's a state senator position. Our state senator passed away because of cancer, you may be aware. I was asked if I would be interested in that position as they were trying to call arrest, and I said no. I'm applying for the circuit judge position. It's a job that I really love, although if I don't get this appointment, I may look at being elected at other points. I will tell you that I have been approached by many law enforcement people who consider me a folk hero, and I tried to correct them and tell them, no, I did not punch this guy. And so I think that people believe that standing up for the clients, and if I didn't say it, I'd need to say it. When I returned to the courtroom, his clients were lined up in the jury's box to make it easy for them to approach the podium. They all cheered because they knew he wasn't serving them well and that I had tried to correct that situation. So I think the incident would only help me, and by the way, I was initially elected to the county bench in a three-way race, which I won in the primary. So I think electability is not an issue that would be a disqualifier.
John, I got a couple of follow-ups, Andrew, before I send it down to you. First of all, thank you for your service to the country. By all accounts, your application is stellar. You were a distinguished jurist for many, many, many years. I find it unfortunate, as I'm sure my colleagues do, that we're talking about this, and you obviously understood it as a major issue because you opened with it. But you keep talking about how you did not physically strike someone, and then you went through the process of where everyone was physically. Is that really not the issue? Hear me out. It's not really, in my mind at least, it doesn't matter whether you hit him or he hit you. To me, it was the decision to get off that bench or the decision to make a threat to someone in the courtroom. Isn't that the real issue? Shouldn't you have gone to his boss, Blaise Tredis? Should you have taken a reflective moment and excused yourself from the situation? Is everything else irrelevant for purposes of what really happened? What am I missing here?
No, I think you've hit it right on the head. And I think the Supreme Court took that approach that the hallway was not the real deal. But I will tell you that we went through a level of different ways to correct his behavior during that 3-month period. Discussions at the bench, discourse in the courtroom, and on a prior occasion we had gone to the hallway to discuss what was going on in the courtroom. So what I'm getting at is, yes, you're right. The real issue was, and I believe the reason why the Supreme Court did what it was that verbal threat on the bench and then getting up from the bench. But I will also say that the public defender testified that he didn't believe we were going to the hallway to have an altercation. He believed we were going to the hallway to have a discussion, as I did also.
Do you think the Supreme Court got it right? Do you think they made the right decision in removing you?
I do not. But because I've been a judge, I make decisions. And I've got to respect those decisions from the Supreme Court, although I'm allowed to disagree with them. And, that has come up as a judge. I was presented with case law where the 5th DCA had spoken, mandatory authority, and there was another circuit that had a contrary opinion. And I said, I have to follow the 5th DCA, but I think the 58th DCA should relook this issue. So,
if you were sitting where I'm sitting, my colleagues are sitting, and when we're done with these interviews, we have to put on a list names, and we have to certify to the governor that these people are the most qualified applicants to serve as a circuit court judge and fill the big shoes of a very respected circuit court judge, John Harris. would you send your name up, having been removed by the Supreme Court and by your own application, deemed to be unfit, and maybe unfit at that moment, but deemed to be unfit? What do you think the governor would do when we send John Murphy's name up, and we are sending a name and saying, Governor, this person's never going to embarrass you? One of my colleagues said one of the most important things we do is we send up names of people who will never embarrass the governor, because if they do, we have failed them in our job. If you were sitting here, how do you reconcile that?
I would definitely send my name up. I believe that if the charge is qualified, I'm definitely qualified. The rest of it, I think, is more politics and media than anything else. But I assure you this won't happen again. And I think that the Supreme Court did get it wrong in their own decision. They said, other than this isolated incident, and as jurists, we usually don't hammer people because of an isolated incident. A course of conduct, even if you analyze all these JQC opinions, which I got to read, obviously, is they always use the words, past conduct predicts future conduct. And yet, in my case, they said an isolated incident was enough.
Andrew?
I've known you for a long time. We've been on the executive council of the Court. I have great affinity for your service. Thank you for your service. I have no questions.
Does the committee members have any follow-up questions for anyone? John, thank you very much. We appreciate it.
Could I have one moment?
Absolutely.
I will tell you that I have been hearing rumors that this may be a family division assignment. Of course, that's always in flux with judges. Normally, February is the time they decide who's going where. I will tell you that just like those opinions that I've put in there, I've served in every division of the circuit court. And if it is a family division, obviously there's some things that I have to update because there's been some legislation as to passive appreciation and things that I don't know what the statute says. And I have always prided myself in preparing and executing in an outstanding fashion, and I will not let you down.
Thank you. Have a nice day.
Thank you very much.